Hi, we're the Group 1 and we're going to report about PD 972, also known as Coal Development Act of 1976. This act aims to first, promote an accelerated exploration, development, exploitation, production, and utilization of coal. Second, encourage the participation of private sector with sufficient capital, technical, and managerial resources in the exploitation and production of coal resources. And lastly, upgrade the technical and financial capabilities of coal industry.
Coal Development Program. Jurisdiction over Coal Development Act shall be under Department of Energy through the Energy Resource Development Bureau. DOE shall not accept any application or proposal for contracts, including applications in small-scale mining permit for coal operations, except during competitive public contracting rounds or bids. Blocking system. Each coal region shall be divided into meridional blocks or quadrangles containing 1,000 hectares or less. No person shall be entitled to more than 15 blocks of coal lands in any coal region. Coal operating contract. Exploration period under every coal operating contract shall be for 2 years. It may be extended for another 2 years and shall be executed in behalf of the government through the DOE Secretary. All materials, equipment, plants, and other installations movable in nature shall be properties of DOE if not removed within 1 year after the termination of coal operating contract. The DOE has primary jurisdiction in the rescission of a contract between coal developers. This is Industrial Enterprise versus Court of Appeals case. Eminent domain. Power of eminent domain may be invoked and exercised for the entry, acquisition, and use of private lands for purposes of coal exploration, development, and exploitation upon prior written notice to the surface owner. Timber rights. The operator may cut trees or timber within his coal contract as may be necessary for exploration, development, and exploitation of the area. The operator granted with timber right shall be obligated to perform reforestation works in accordance with the regulations of FMB. Water rights. A coal operator shall also enjoy water rights necessary for exploration, development, and exploitation of its coal contract area. But water rights already granted or legally existing shall not thereby be impaired.
And now let's discuss about RA 7638. This is also known as Department of Energy Act of 1992. The department is mandated to prepare, integrate, coordinate, supervise, and control all plans, programs, projects, and activities of the government relative to energy exploration, development, utilization, distribution, and conservation.
Republic Act No. 7638 created the Department of Energy in order to prepare, integrate, coordinate, supervise, and control all plans, programs, projects, and activities of the government relative to energy exploration, development, utilization, distribution, and conservation. The department was vested additional powers and functions under pertinent energy and power-related legislations, such as Republic Act No. 9136 or the Electric Power Industry Reform Act of 2001, Republic Act No. 9367 or the Biofuels Act of 2006, and Republic Act No. 9513 or the Renewable Act of 2008. The Department of Energy is composed of the Office of the Secretary and the offices of the Undersecretaries and Assistant Secretaries, and the bureaus and services of the department. The incumbent Secretary of the Department of Energy is Alfonso Cusi, who assumed office on June 30, 2016. Under said law, the Secretary shall have the following functions: A. Establish policies and standards for the effective, efficient, and economical operation of the department in accordance with the programs of the government. B. Exercise direct supervision and control over all functions and activities of the department as well as all its officers and personnel. C. devise a program of international information on the geological and contractual conditions obtained in the Philippines for oil and gas exploration in order to advance the industry. D. Create regional offices and such other service units and divisions as may be necessary. E. Create regional or separate grids as may be necessary or beneficial. And F. Perform such other functions as may be necessary or proper to attain the objectives of this Act. The Secretary, with the approval of the President, has the power to reorganize, restructure, and redefine the functions of the bureaus and services for the effective discharge of the powers and the functions of the Department under this Act. These are the Energy Resource and Development Bureau, Energy Utilization Management Bureau, the Energy Policy and Planning Bureau, the Electric Power Industry and Administration Bureau, the Oil Industry Administration Bureau, the National Transmission Corporation, the Power Sector Assets and Liabilities Management Corporation, and the National Electrification Administration. Now, we go to the Energy Regulatory Board. The Energy Regulatory Board provided policy guidelines and regulatory framework for the activities and operations of the power sector. It also regulated the business of importing, exporting, shipping, transporting, processing, refining, and marketing and distributing of energy sources. It was also given the power to determine, fix, and prescribe rates, including penalty charges of all energy providers, prices of petroleum, pipe gas, and pipeline concessionaires. When Republic Act 9136 or the Electric Power Industry Reform Act was passed, it created the Energy Regulatory Commission as an independent, quasi-judicial regulatory body, thereby abolishing the Energy Regulatory Board created under Executive Order No. 172. The Energy Regulatory Commission is tasked to promote competition, encourage market development, ensure customer choice, and penalize abuse of market power in the electric industry. To carry out this undertaking, the Energy Regulatory Commission promulgated necessary rules and regulations and imposed fines and penalties for any compliance or non-compliance with or breach of the IPURA and the other rules and regulations which it promulgated or administered, as well as other laws it is tasked to implement or enforce. Among these powers carried out by the Energy Regulatory Commission are 1. The regulation of amounts of rates charged by public utilities. 2. The statutory authority to issue provisional rate increases. 3. Granting application for rate adjustment of any relief reflecting consumers. And 4. Regulation of acquisition costs of electricity through competitive public bidding for power purchases for distribution utilities. Among the fines and penalties discussed under this law are as follows. 1. If any person is found guilty of any of the prohibited acts under Section 45 of said law, shall suffer the penalty of prisión mayor and a fine ranging from 10,000 pesos to 10 million pesos or both at the discretion of the court. 2. Members of the Board of Directors who knowingly or by neglect allows the commission or omission under the law of the juridical companies participating in covered or intergeneration companies, distribution utilities, the Transco, or its concessionaire or supplier who violate provisions of this Act shall be fined by an amount not exceeding double the amount of damages caused by the offender or by imprisonment of 1 year or 2 years or both at the discretion of the court. 3. If the offender is a government or official or employee, he shall be dismissed from government service with prejudice to the reinstatement and with perpetual or temporary disqualification from holding any elective or appointed office. And lastly, if the offender is an alien, he may, in addition to the penalties prescribed, be deported without further proceedings after the service of sentence. In any case which involves question of fact regarding this law, it shall be appealable to the Court of Appeals, and those which involve question of law directly appealable before the Supreme Court. we now tackle the issue on oil deregulation. Deregulation generally means the lifting of government control and letting market forces work in the business. For the local oil downstream industry, the concept of deregulation covers two things. First, price decontrol, and B, removal of restrictions on the establishment and operation of facilities as well as the importation and exportation of crude oil and petroleum products. One of the controversial laws passed in accordance to the oil deregulation policy in the Philippines is Republic Act 8180, or otherwise known as the Downstream Oil Industry Deregulation Act of 1996. In 1997, in the case of Tatad versus Secretary of the Department of Energy, the Supreme Court declared it as unconstitutional for violation of the prohibition against restraint of trade, unfair competition, and regulation of unmitigated monopolies. It was because of said law that it imposed tariff differential of 4%, which discouraged new players to enter the downstream oil industry to the advantage of major league players like Petron, Shell, and Caltex. Following the thumping of RA 8180, Congress enacted a new deregulation law, which is the Republic Act 8479, or otherwise known as the Downstream Oil Industry Deregulation Acts of 1998, in order to liberalize and deregulate the downstream oil industry and to ensure a truly competitive market under a regime of fair prices, adequate and continuous supply of environmentally clean and high-quality petroleum products. Before the start of the deregulation, it was Shell, Caltex, and Petron who controlled the entire oil industry in the Philippines. And now, in the advent of RA 8479, importers and purchasers of quantity crude oil and petroleum from foreign and domestic corporations are now being monitored by the Department of Energy under a single and uniform tariff treatment while promoting fair trade practices to prevent cartelization, monopolies, combinations in restraint of trade, and any unfair competition.